Hello everyone, and welcome to this, the latest instalment from the 2TG employment team, giving a monthly update on hot employment law topics. My name is Tom Fairclough, and I am a barrister at 2 Temple Gardens, specialising in, amongst other things, employment law. And before being a tenant in chambers, I was a Judicial Assistant at the Supreme Court, where I worked on cases such as Uber and Aslam, Royal Mencap Society and Tomlinson-Blake, and Asda Stores Ltd and Brierly. This talk is going to be on the thorny topic of continuing acts, discrimination and limitation periods, and this is something that is often pleaded, but perhaps not properly thought about or particularised at the earlier stages of litigation. And the aim of this talk is to give a short overview of some of the main battle lines in this, I think, incredibly important, but also incredibly interesting area of law. So the first slide gives the general rule on limitation. As we all know, in a personal injury case, you have 3 years to bring a claim. Breach of contract, it's 6 years. Discrimination, however, attracts a much shorter time period in which to bring your claim. You have 3 months from the date of the act to which the complaint relates, and that's section 1231A of the Equality Act 2010. There are 2 important caveats to this. The first is that the tribunal can extend the time period if it is just and equitable, and that's section 1231B of the Equality Act. And this often creates arguments between the parties, and there is a wealth of case law on the point, a discussion on which you might be glad to know is outside the scope of this short talk. The second caveat is that the 3 months is interrupted by following the ACAS period, or conciliation process, and that's section 140B of the Equality Act. And that is something that is not always perhaps fully appreciated or fully understood, but it is important when considering whether to plead limitation to take account of it. This talk, however, only talks about the default 3-month period and when it runs from. So the next slide is titled, When is the Act complained of? And specifically, how does this work when there is said to be ongoing conduct or an ongoing event, so a policy that is discriminatory because it prevents women being promoted, for example? Well, section 1233A of the Equality Act says that conduct extending over a period is to be treated as done at the end of the period. And in this talk, I want to explore how that applies in the area of policies versus decisions. It's important because it can, and frankly should, impact on how you set out your claim or your grounds of resistance if limitation might be an issue. And I should say now, at the beginning, that the latest the time can start to run is usually dismissal, so a lot of what I'm going to say won't actually matter if the person has in fact been dismissed. So the next slide looks at Barclays Bank and Kapoor. This is, if not the main case in the area, it is the only Supreme Court or House of Lords authority, and it is a useful starting point and reference, not least because the vast majority of subsequent cases go through Kapoor, often in quite some detail. And I'd note that this case was decided under the Race Relations Act, not the Equality Act, but it is still good authority. In short, the claimants were employed by a bank in East Africa. They moved to the UK to keep working for the bank, and they were of Asian descent. Their previous service with the bank was not taken into account in calculating their new pension arrangements, but they said that European colleagues' past service was taken account of. They alleged discrimination, and the bank pleaded limitation. The claimants argued that the discrimination, continued over the length of their employment because it was ongoing. The respondents, in effect, argued that the alleged discriminatory act took place at the time of their recruitment, i.e. when this policy was applied to them. What the House of Lords said was this: the matter can be tested by taking the case of an employer who, before the act was passed, paid lower wages to his Asian employees than to his white employees. Once the act came into force, the employer would be guilty of racial discrimination if he did not pay the same wages to both Asian and white employees. if he continued to pay lower wages to the Asian employees, it would be a continuing act lasting throughout the period of an Asian employee's employment within the meaning of subsection 7b of the Race Relations Act. A man works not only for his current wage, but also for his pension, and required him to work on less favourable terms as to the pension is as much a continuing act as to require him to work for lower current wages. So it's an ongoing policy rather than an individual act that constituted the alleged discrimination, and so time hadn't started to run just because the policy was first applied to the employees. The IDS Employment Law Handbook sums this up by saying it would not be any answer to a complaint of race discrimination that the allegedly discriminatory pension arrangements had first occurred more than 3 months before the complaint was lodged. And the next slide gives the key distinction, a continuing act versus continuing consequences. And that's because the distinction is, as a rule of thumb, between a discrimination regime, policy, rule, and so on, versus an individual allegedly discriminatory act, albeit one that can have lasting consequences. And so in the case of Salgren and Haringey Health Authority, which provides an interesting contrast to Kapoor, a black staff nurse was employed. She was graded at grade E. She appealed and wanted to be regraded at a higher grade. That appeal was dismissed. And a white staff nurse was graded more highly. The black staff nurse complained 6 or so months later. She lodged a complaint with the tribunal, and limitation was an issue. The court looked at the difference between whether a discriminatory act was a once and for all act, albeit with ongoing effects, or a continuing policy. And in this case, it was said by the claimant that the respondent paid the claimant lower wages than the comparable white employee, and this act continued throughout her employment. But the Court of Appeal disagreed, stating the fallacy in this submission lies in failing to identify and differentiate between the discriminatory acts relied upon by the applicant and by Lord Griffith's hypothetical claimant in Kapoor. In Lord Griffith's example, it was the employer's policy not to pay the same wages to the Asian and white employees. It was that policy which constituted the discriminatory act. In the present case, it has never been suggested that the local health authority had any such policy. Its policy was quite clearly to pay the same wages to every employee in the same grade, regardless of racial distinctions. The applicant's complaint was quite different, namely that she had been refused an F regrading for racially discriminatory reasons. And the claimant therefore lost, because what the Court of Appeal does is seemingly endorse a statement in a case called Amy's, where it was said the discriminatory act was the appointment, which was a once and for all act. The loss of pay was but a consequence. It would have been otherwise if the employers had operated a rule or policy that only men were eligible for the appointments as departmental heads, since this would have been a continuing act. And so what one can see from those cases, I think, is how important framing these things is. It matters if you say it's an ongoing policy or an act, and it can have effects on when limitation starts to run. You can contrast the last case I spoke about, Salgren, with Owusu, in which an employee wasn't promoted, and whilst the EAT could see the argument that the failure to promote, the decision not to promote, was a single act, in that case, the claimant had framed it as a policy, rule or practice, in accordance with which decisions were taken from time to time, and that was sufficient to be a continuing act and help the claimant on limitation. And that leads me to the next slide, which is called Policies and Discretion. So can it always be said that if it is an ongoing policy, even one that acts have been taken under, then it is a continuing act sufficient to delay limitation from beginning, despite the fact the detriment or the claimant may have been put to a detriment seemingly months or years before they lodged a complaint. The Court of Appeal have recently said, well, it really rather depends, and this is a case called Parr and MSR Partners LLP. In that case, the claimant was an equity partner in an accountancy firm, and the membership agreement provided for retirement of equity partners on the 30th of April after the equity partner's 60th birthday. The claimant reached that milestone but wanted to continue as an equity partner. Under the membership agreement, the managing partner had discretion, subject to approval by the partnership committee, to keep someone on as an equity partner. And there had been instances where that discretion had been exercised to keep people on. In this case, the managing partner offered the claimant a chance to be an ordinary partner only, so not an equity partner, after the 30th of April following his 60th birthday. And sometime later, the claimant brought a claim for age discrimination, and the respondent said, no, you're out of time, and pleaded limitation. On a preliminary issue trial, the claimant argued there was ongoing conduct because it was the membership agreement that forced retirement, and the claimant was still an employee, and so a discriminatory rule still applied to him, i.e. he was no longer an equity partner because of an age-related discrimination. The respondent said, by contrast, that this was a one-off act, albeit one with continuing consequences. The fact was, according to the respondent, that discretion had been exercised, the discretion not to allow the claimant to stay on as an equity partner, and that, the respondent said, was the act in fact complained of, and that had taken place far more than 3 months before the claimant brought a claim. Lord Justice Bean gave the main judgment, and he said that a dismissal is a one-off act, and so it's unclear why a demotion should be different. Further, he said, the case law does draw a distinction, at any rate when analysing whether the conduct complained of is an act extending over a period, between a rule, policy or practice which inevitably leads to the rejection of the claimant, and one which involves in practice and not just on paper, so in substance, not just in form really, the exercise of a discretion. And the claimant in that case lost. The fact of it being a demotion, a sort of positive act, and a discretion, so an individual decision having been taken, militated against a continuing policy being found that continued to apply. This was instead a one-off act, i.e. a one-off demotion, albeit with continuing consequences, and limitation therefore ran from that one-off act. So what Parr does, I'd say, is reinforces the idea that what we're looking for are continuously running policies versus acts, even if those acts are taken under policies that are really one-off decisions. Even within that, it is difficult. For example, what if there is a policy that heavily shapes the exercise of discretion? Is a decision taken under that policy a one-off act sufficient to start the limitation clock, or is it part of an ongoing policy sufficient to delay limitation from beginning? And in my view, it will depend on the facts of each case, and it is telling that Lord Justice Bean says discretion in practice and not just on paper. And one can imagine many arguments around whether, in fact, there was a real exercise of discretion sufficient to start limitation running, or whether, in fact, there was a policy that was ongoing that stopped, for example, an applicant being promoted. The next slide is called Always a Question for the Tribunal, and this notes that whilst we have these classifications, these distinctions of policies, discretionary acts, continuing acts, and so on, it is important to note that the Court of Appeal have said the Tribunal shouldn't be too literal in looking at limitation and the relevant sections of the Equality Act. And what the Court of Appeal have said is the concepts of policy, rule, practice, scheme or regime given in the authorities were given as examples of when an act extends over a period. They should not be treated as a complete and constricting statement of an act extending over a period. The focus should be on the substance of the complaint, and the question is whether the act complained of is an act extending over a period, as distinct from a succession of unconnected or isolated specific acts, for which time would begin to run from the date when each specific act was committed. And so what that's saying is you really have to look at the substance here, look at the complaint that is made. And so in my view, it's important to think creatively about what your case is and how you say it is a continuing act. The next slide gives some practical tips to sort of round off this whistle-stop tour of the case law. And I think there are three. The first is think about limitation early. Do give due thought to it when, for example, pleading a grounds of resistance, because you'll be setting the tone then, and setting the scope of the arguments that you might be having many months or even years down the line. Second, think about how to frame your complaint or response so as to maximise your own limitation arguments. So think about, is this a policy or is it a one-off act? If it looks like there was a discretion and a decision, well, look at, in fact, are women ever promoted under that discretionary policy? Is it in fact just a rubber stamp and part of an ongoing discriminatory policy that you're subjected to? Think about those sorts of arguments and think about how they fit into the rest of the framing of your case. And third, people often want a preliminary issue trial on limitation, and that can be useful. It can save costs, but it is important to think carefully. Will it just increase costs? Will you lose a negotiation tool? Are you looking at something that might just result in appeals? And even if you have a good argument on limitation, either way, and so you do have a preliminary issue trial, if the claimant is going to ask for an extension of time because it's just inequitable to do so if they are outside of the 3-month period, then it is worth asking the tribunal to consider both whether the 3-month period has passed. So the initial is the claimant on the face of things past limitation when they brought the claim. And if so, it's worth asking the tribunal to then look at the extension argument if the claimant's making an extension argument because it's just unreasonable, just inequitable to do so. The tribunal didn't do that in Parr. They said the claimant's past time, didn't go on to look at whether it was just inequitable, which means after, I can only imagine, an expensive tribunal, EAT and Court of Appeal battle, Parr has had to go back to first instance on the question of an extension, which clearly is to nobody's benefit. That ends the talk. Many thanks for coming, albeit virtually. And if you have any questions, please do feel free to drop me an email or give me a call. My contact details should be appended to the email with the talk. Thank you very much.